is I'm going to I'm going to put Peggy on when she gets through. Dwayne Rogers comes on. So when I'm through with these few last notes I've got for you, I'm through for the day, or actually for the weekend, and then my other officers will take over and finish you up. First thing I want to point out, you may have noticed that Peggy isn't bashful, and I've got to tell you, let me tell you how good she is, because she will never tell you this herself. She's so good in an open courtroom that when she walks into a courtroom, normally about 24 lawyers will file in behind her just to watch her in action. You can do the same. Another thing, some other minor things I want to cover. Whenever you sign a legal document, you sign it in blue ink, because if you sign it in black ink, you will not be able to sort out the Xerox copies. And any copy that is signed in blue ink becomes an original. Next thing I want to point out is Ambassador Fox reminded me during one of the breaks, is that Blackstone's commentaries were the law book that everybody had prior to our Revolutionary War. In other words, it's a real good summary of the English common law, and it's definitely something you should have right after the Rules of Civil Procedure and Black's Law Dictionary. One of the things I did not cover was discovery. I'm going to come back to that in a minute. There are other law book publishers besides West Publishing Company. West Publishing is kind of geared towards prosecutors and big business and big government. There are other companies like the Mitchie Company out of Virginia, M-I-C-H-I-E, Clark Boardman out of New York. There are a number of other law book publishers, and I got to tell you, some of these law books are literally worth their weight in gold. I bought one set of books by McCarthy, some outfit out of California. I believe that, I'm trying to think of the company, that might be Matthew Bender that carries it. It's called Bad Faith Insurance, what to do when your insurance carrier stiffs you. And a friend of mine paid $180 for these books, and he read the books, and I coached him through a bad faith case, and he collected $10,000. And then the skinflint was going to send the books back because he didn't need them anymore, so he could get a refund. And I said, no, I'm not going to allow you to do that. I said, I need these books. I use those books, and thanks to that one set of books, I've had 5 bad faith insurance companies or bad faith insurance cases that I've walked people through, and I have lost 0 of them. It's the one type of action when an insurance company stiffs you. The courts have no sympathy for insurance companies. They're really kind of neat outfits to sue because the odds are in your favor. Another thing I want to point out here before I get back to discovery is that, and I've said this repeatedly, is that the law is a weapon. Now imagine yourself in 1797, you're on the frontier, and you've got a problem with an Indian war. Well, you have one of two choices. You learn to use the weapons yourself, or you hire mercenaries, because nobody is going to come over free gratis and kill your Indians for you. Next thing is, this is also from Sun Tzu, is what is important in warfare is to attack the enemy's strategy. And we've already given you examples of that. If the enemy's strategy is to send motions that you don't know about or to bribe the clerk, don't attack what he's doing, or him, you attack his strategy. When you derail an attorney's strategy and they see it coming from a pro se litigant, a lot of times it's like they'll look at you like a truck ran over them, because that's the last thing they were expecting. In some courts, some federal courts, what you will have to do, and this is also true of a lot of state courts, is when you have a motion pending, in other words, you want to put in a motion to do this or a motion to do that, you will have to call the clerk and get time, date, and place. In other words, you have to set it for a hearing, and then you have to notify the other side. You'll see that in some courts, and in some courts you just throw the stuff in and they get to it when they can. Now, what I want to cover on discovery, because a fellow brought this up during the break, is that a lot of times what will happen is when you make somebody snitch on himself, he will buck like you can't believe. Well, discovery goes this way. Number one, you file for the discovery. You're asking somebody, say, Federal Rule of Civil Procedure 33, written interrogatories. You ask a guy up to 25 questions. He refuses to answer. So then you go in for what's called a motion to compel. And what you're doing is you're asking the judge to issue an order to tell this guy he's got to answer the questions. Well, of course, he figures you don't know any better, so he doesn't answer the questions even after there is a court order. Court orders are not self-enforcing. The next thing you do is, and there are one or two things you can do here. You can apply for sanctions, that's Rule 37, or you can ask the judge to cite the other side for contempt of court. Now, what will happen is if you play this out, now here's the beauty of this discovery system. It's not supposed to be used like this, but hey, you know, any weapon properly applied, if somebody else doesn't like the way you've applied it, so what, as long as it doesn't get you in trouble with the system itself. What you can use discovery for, in other words, see, most people, they'll throw in like 25 questions. Not me. I'll throw in 5. I'll get those answers, I'll throw in 5 more, and I will keep continuing to build a trap for them. But actually, one of the other things I'm doing, and I'm not going to cover this too much because it's already in my books, but one of the other things I did not cover in my books is this, is that when you file for discovery and you get motions to compel and you get sanctions, there's only so much of this discovery, motion to compel, motion for sanctions crap the courts are going to put up with from the person who is not cooperating. And that goes for you too. In other words, if you're a defendant and you think you can get cute and drag your feet and run somebody through this, don't even think about it. And anyone who's got 2 brain cells to rub together will not think about it either, for the very simple reason that if you do this often enough, and sometimes it only takes like maybe 3 times, the judge will get so ticked, and he's got the statutory authority to do this, he'll issue what are called termination sanctions. You might as well not have even answered and got a default judgment, because what the judge is saying, you refused to cooperate in discovery, you didn't play by the rules, you just lost the chess match, and the appeals court will uphold it, and it'll stay that way for all eternity. So again, you've got to play by the rules, and you've got to play by their rules. And when I say their rules, I am not talking about the rules they make up as they go along. I'm talking about the rules of civil procedure, the statute law. You've got to understand how the game is played. Now, again, what's going to happen next is Peggy Daddick. Why don't you start up here, front and center. I'm basically through for the day. I'm going to turn Peggy back over to you. Oh, wait a minute, I got one question. Hang on. Up here to the mic, please.
I have a trial coming up next month, and they've asked for a jury trial against me.
Okay, whoa. Criminal or civil? Is this a civil trial for money damages or a criminal trial they're going to try to lock you up?
They're trying to get money damages.
Civil, okay. State or federal?
State.
State, okay. What state?
North Carolina.
North Carolina, okay. All right, now that we've established that you have a state civil trial, which I assume you are the defendant, correct?
Yes.
Okay, plaintiff and defendant, you got to be one or the other, okay? You are not the suer, you are the suee. That's right. The defendant, all right? Okay, now what is the question? I've established the parameters of where we're operating. What is the question?
We had a contract, and I sold this guy a piece of property. I gave him 60 days to exercise an option on another piece of property, which he did not do. So then, 2 or 3 months later, I called him and sent him a note and saying, if you're going to do anything on this other piece of property, you need to do it. His comment was on the telephone, he said, well, I don't even have the money right now to pay the lawyer to do it. But what he did in the meantime, he gave me all of his down payment on the first piece of property so that he could take his second piece of property with no down payment.
Okay, what's the question?
So now, after his time run out for about 6 months of the option, then he sent me a letter and he says, I'm going to sue you.
Okay, wait a minute. Do you have an attorney on this case?
Yes.
Do you have an attorney?
Supposed to have an attorney.
My one question to you is, I already see what this is, okay? In other words, you had a contract, you had offer and acceptance, which is what you have to have in a contract. If you make an offer and the other side doesn't accept it, that is not a contract. He's got nothing to sue you over. My question to you is, has your attorney filed a motion for failure to state a claim? Yes or no?
No.
Then get on it. Get on it. Oh, that's only federal, not necessarily. North Carolina's 12b6 too? Okay, man just told you, that's what it is.
Well, what now?
North Carolina Rule of Civil Procedure 12b6, and in fact, this is the fella that just told you that, was just primed me on the discovery thing, because you know it slipped my mind. But this guy here, go back and listen to him because he's a veteran. All right, he's been on the battlefield more than once. Yeah. Motion to dismiss for failure to state a claim, and if you would, let me take the next fella here.
Okay.
Okay.
Thank you.
Yeah.
I'd like to ask, what is the patriot mythology that's grown up in connection with the use of without prejudice relative to UCC 1-207?
Okay, UCC-1-207. It has all the legal validity of throwing chicken bones on the ground and predicting the future, okay? The problem you have with the Uniform Commercial Code is this. Number one, it is a uniform commercial code. It does not apply to criminal actions. It does not apply to most actions where the state comes against you. It only applies to transactions against merchants. But you have another problem, is that the UCC is only the law in the states that have adopted it. Some states have adopted it entirely, some states have adopted it in part, and some states have not adopted it at all. So what you have to do is, if you think you have a UCC problem, and I've run into this before, what you've got to do is, see, I'll guarantee you, you didn't read the statute book on that, right? And I'm not trying to front you off, but I'm just asking a question here. You have not actually gone to the statute books and read the UCC 1-207 and how the courts have interpreted it, correct?
No, I have read it.
Okay. No. I'm asking you, have you read the cases?
I don't believe I've read all the cases now.
Oh, okay. What I'm telling you is UCC-1-207, basically what it does is, if you really want to know, you put that on a legal document, and I've got a fellow here, I'm not going to mention his name, he had a jam-up piece of work, and then he signed it, UCC 1-207. It brands you as an amateur, okay? In other words, it basically tells the court, this guy doesn't know what's going on. Don't use it, okay? Unless you happen to have a transaction between merchants, then it's fine. But look, every statute has a particular use, all right? Uniform Commercial Code, in most places, it's got nothing to do with anything, okay? You take the next one.
Michael, UCC 1-207 says performance or acceptance under reservation of right. In your state code, in the index to the state statutes, there will be a listing for either commercial code or uniform commercial code. If you hear talk about the UCC and you want to apply it in the states, don't use UCC, use the state number, and be double damn sure that your state's number matches the UCC number that you are prattling on about. Thank you.
Okay.
Go ahead.
Yeah, I live in South Carolina. Company in Boston.
Whoa. Back up from the mic just a bit, will you? Okay, now.
I'm in South Carolina.
You're in South Carolina.
Company in Boston.
All right.
Took some money out of a mutual fund account at the request of the IRS without a court order sent to the IRS.
Okay.
How could I sue them from South Carolina to Boston for $3,000? And can I get punitive damages on that?
No, you can't, because here's your problem. The IRS is the one area in which you have even fewer rights than anywhere else. If
They
you
did not have a court order, though. Doesn't that make a difference?
You have a court order that says what?
No, they did not have a court order. Now, I've got cases where they can't take you money without a court order.
Okay. Now, if you have cases, do you have any of those cases with you?
No, not with me.
Okay. Now, are these federal cases? How recent are they? Have you shepherdized them?
1980s.
1980s. That's fairly recent.
Yeah,
Okay?
shepherdized them. They're still
Now,
on the
the
book.
problem is, wait a minute. One of the problems we're going to have here, because everything I've seen in the IRS, the way that they normally operate, they even have what they call the anti-injunction statute. In other words, if the IRS takes your money, you can't even begin to get it back until you have litigated it. If they're getting ready to put a levy on you, if they're getting ready to take everything you own, you can't litigate it to try to stop them. In other words, they actually have federal statutes that say when the IRS has got its beady little eyes on your bank account, there are actually federal statutes that say that what's going to wind up happening here is that no court is going to issue any type of injunction to keep them from doing what they're prone to do. And they've got a really slick setup in that if you want to adjudicate the thing in the tax court before they get the money.
No, I want to sue the company, the mutual fund company that gave them my money without a court order.
The problem is, though, is that here's what's going to wind up happening. They had a levy from the IRS, right?
But there were no warrants of distraining. I've got a case that says we've got to have warrants of distraining.
Okay, if you have a case, all right, and quite frankly, I'm a little skeptical, all right?
No, I've got the case.
I understand, but who was the case issued by? Which court did it come out of? Are we talking, is this a federal district court case? Is this a, Boston would be the First Circuit? Okay, is it a First Circuit case? What kind of a case is it? Okay, well, so you've got to find out, because let me give you something real quick here. If you have a federal supplement case that says that, it won't hold water for one very simple reason. Federal district court cases are not precedent. They're not even precedent in their own courtrooms.
This case came out of U.S. Reporter.
Okay, if it came out of the U.S. Reporter, United States Reports, you mean?
Yeah.
Okay, that would probably be a Supreme Court case, all right?
Yeah,
but let me caution you on something. Okay, let me caution you on something. And I'm not saying this to denigrate your intelligence or anything, because I run into this all the time. I've run into it for 25 years. People have a tendency, and I'll guarantee you if this is what it is, and I don't know that it is. Okay, I haven't read this case. You don't have it here. I can't read the header notes, so I'm basically flying blind. I don't know if you're right or wrong. But the one thing I want to caution you about, when you start reading a case, and this is real easy to do, you may have 4 separate things on one page, all right? And one of them may say exactly what you're saying. But if you read down a paragraph or 3, you may find that what they're actually addressing is a mistake of law somebody made, and then down here they're telling you why it's wrong. I don't know, but it's been my experience with IRS cases that everything is in their favor. And the thing is...
Just, Kurt, I may have the case with me. Are you going to be around?
Yeah, if you have the case with you, you bring it out here, and I'll take a look at it. What I'm going to do is, because I'm through for the day right now, as soon as Peggy gets back up here, is if you have that case, what I want you to do... Well, wait a minute. What I want you to do is if you come outside with me and you show me this case, and you and I are going to have a discussion, if I show you something you haven't seen before, I want you to come back up here and explain it to the audience, okay?
Okay.
Fair enough?
Fair enough.
Okay, Peggy, let's get back on deck. And that's it for me for the day. And incidentally, I appreciate all you people showing up. You still have quite a ways to go.
Okay, more war stories, I guess. Michael mentioned Black's Law Dictionary to you along with the rules of court. Let me tell you what we found has been the best way to use Black's. When you go to the law library and you pick up some cases, you find some cases that you think are going to support your position, or when you get any piece of paper from the other side, the smartest thing you can do is to sit Black's Law Dictionary on your desk and read that paper with Black's right alongside of the piece of paper. And any word in that document that you even think might have one English meaning and one legal meaning, you look up in the dictionary. And after 3 or 4 weeks of doing this, you cannot imagine how much of that legal terminology is going to start sticking. Because what happens is when you go to read those cases in the beginning, you go to the law library, you find your first case, you do some research, it is dry material to read, okay? It's not fun. I mean, you sit there, you read the first paragraph, and you get to the end and you say, what did I read? Because it's really not easy to understand. I'm going to tell you folks, you need to read it 3 times, 4 times, 5 times. That's what you have to do. But by the 5th time, it starts to clear up, and you start to understand it, and you're getting something out of it. And that's the way you read law material. And 3 or 4 months down the line, you'll only have to read those cases once when you find them, because the terminology will be there. It's a new language. It's just like learning a computer. It's just like learning a new job. Every job has buzzwords. The legal system isn't any different. The only difference is they've convinced all of us that we couldn't possibly understand it. But they have the key. The key is Black's. You've got to have that book. That's one book that absolutely belongs in your library, along with the rules of civil procedure. Another thing my husband said to me, if you have a question, we'd ask that you come up to the microphone. My husband said to me, make sure you tell everybody, and this seems so basic, but it's very important, that if they've got something that's going on in court, that they absolutely have to get there on time. I gotta tell you, I saw somebody do this just last week. They had a dynamite motion put together. They were going in to recuse a judge who was very unfair, very prejudiced against pro se litigants. They had the paperwork all lined up. They had a court stenographer there. Well, the court stenographer was there with her little tape recorder all ready. And 20 minutes later, after the proceeding had started, this person walked into the room. How could you possibly think that you could win if you're going to walk in late? I mean, even the judges are never late. They're always there on time. You just don't do that. You have to be there well in advance so that by the time you get into that courtroom, you're set and you don't have any problems. Yes, sir, you had a question?
Is there any specific important difference between the 6th edition of Black's Law and the ones that precede that, 5th, 4th, 3rd, 2nd, as far as you're concerned? Yes.
I know that there's a lot of information out about Blacks in the different editions. I have never done a lot of research. I won't have a good answer for you on that. The one that all the lawyers use and the courts use now are, of course, the 6th edition. You wouldn't go back and look for old definitions to support your position today. That I can tell you.
I have a used bookstore, and I've had a run on Black's Law Dictionary, anything before the 6th edition. And I suppose it's the Patriots.
It is the Patriots. And
that's the reason for my question.
I'm sure there's valuable information in the old editions that may not have seemed appropriate for them to include in today's edition. But again, if you're looking for something to fight today in court with, you're looking for the most recent cases. Michael talked about shepherdizing. Shepherdizing is something that when you're first learning and they're saying to you, oh, did you shepherdize your case? You say, what in the world is that? Okay, well, it's not too much harder than learning the Dewey Decimal System in a regular library. I mean, you go in there and you learn how to do it. There's a very good book that's sold by Nolo Press out in California, and it's How to Use the Law Library. It's probably about $15 or $16, and it shows you everything that's in the law library. I think there's 3 or 4 pages on how to shepherdize. Michael has information in the cookbook, but if that's not sufficient, if you feel like you need more, then this Nolo Press book is a real good backup. Nolo Press is out in California. I don't know the number offhand, but it's listed on the 800 exchange because it is an 800 number.
On the board.
Okay, it's on the board. So you just, if you need the number for Nolo, come up here. Nolo has some good books out, Nolo Press. There's another good book that's put out by Nolo Press for those that are actively in court, and it's called How to Represent Yourself in Court. It's written.
Just repeat that number for the tape.
Okay, Nolo Press. Okay, 1-800-992-6656. And your bookstores, your local bookstores can get these in for you too, because we've ordered them down in Florida through some of the local bookstores if you don't want to order directly through Nolo. But the other book is How to Represent Yourself in Court. It's written by 2 attorneys, and this book is dynamite because it shows you how to organize your papers, okay? How to organize your files. You have to be very organized. If you go into a law firm and you see how they have your files set up, you pretty much have to do that so that you get something in the mail, you don't go to some box and start sifting through papers when you have a hearing tomorrow that's going to take you a week to find everything. You just file things as they come in chronological order. You get yourself a folder, you get yourself a 2-hole punch because the courts punch everything on the top of the sheet. 2 holes up here, that's how everything gets filed, and you might as well do the same for you. This way you go file 1 copy with the court, get your copy stamped, you bring it home, you make a log in the front of it, so you can just go to that log and say, in March I filed this, in March I got this from the other side, and everything is there because you're going to need it. When you get to the, I mean, things just keep coming back. They don't stop in that case. And later on down the line when that lawyer says, we never discussed this, and you've got a record that you can put your finger on and say, wait a minute, this was decided and the court ruled in my favor 6 months ago. can be real glad that's all organized.
Peggy, just following up on that last question, I did find a difference in Bouvier's, the 1856 edition and the 1914 edition of the term voir dire or voir dire, which today is the process by which they ask intrusive questions of prospective jurors. And originally that meant the statement of a witness in a case that he has no interest in the issue at hand.
Oh, okay, that's very
So
interesting.
it sort of swapped it around, translates as to speak the truth. But let me ask you about the court reporters. You talk about bringing the court reporter in with you, your own court reporter. I have heard that the courts will frequently not allow an unofficial reporter into the court. They would allow only the court's reporter, and that would be the official record, and there would be no challenge of it once certified. Can you?
Yeah, I'll be glad to address that. Okay, that's what they're going to tell you. If you call up, a lot of the courts will say, you call up the clerk's office and you say, well, I would like to know what I have to do to be able to bring my own court reporter. And the clerk will say to you, oh, you're not allowed to. We have our own official court reporters. Here's the answer. Weeks before the hearing, you have to put in a motion asking the judge permission to bring a court reporter with you of your own. Very simple. Here comes so-and-so. I would like to request permission from the court to bring my own court reporter in addition to the court's reporter to a hearing on such and such a date, such and such a time. The court will most frequently grant it when you come in advance. You cannot come in there at the last minute with your court reporter. They will not let her in the door in the federal courts. State courts, you've got to find out what your local rules are, but you definitely can. And I can tell you, we just ran into this. Michael and I had an appeal on a very old case that some lawyers had blown for us up in New Jersey. It was a car accident case where my husband had been injured. And once we found out how to do this in Florida, we went back and sued the attorneys and the insurance company in New Jersey who did that to us over there. So we lost the case at the first level, and we went up on appeal, and we had oral argument up in Pennsylvania in Philadelphia about 6 weeks ago. And on the way up, we said we had hired a court stenographer, and we had drive up from Florida, and on the way up, we're waiting for this permission, and of course it didn't come before we left to go, but we did get permission. But it was gotten at the last minute. On the last day, we had faxed the motion in. They allowed us to do that. And everyone was in a meeting. The clerk's office was in a meeting. So I guess about the 5th phone booth stop on the way up from Florida, I finally got to somebody and said, listen, I'm stopping every 25 miles on I-95 on my way there to find out if I got the motion approved or denied. So the girl said to me, well, everybody's in a meeting, but let me see what I can find out. And she came back and said, oh, the judges said no problem, and you can do it, and the order's been approved. Well, I guess the clerk that the attorneys that we were fighting was in the meeting. The clerk that the attorneys that we were fighting was dealing with, he wasn't there. So when we arrived in the courthouse the following Monday, we got there, and the court reporter was there. And the clerk came over, this little guy in a real neat suit, and he came running over in a panic. He said, who are you? Because she had the the recorder and her microphone she was setting up at the panel. Because when you go up on appeal, if you have an oral argument, it's usually a 3-judge panel that's sitting up there that you have to address your argument to. And so she was setting up her microphones. And this clerk came running out, and he said, what are you doing here? And she said, well, I'm just setting up the microphones because I'm the court reporter. He said, oh, no, that's not allowed here. So I got up and went over to him. The judge wasn't in the courtroom yet. And I said, no, we have...
Hello.
Hello. How are you?
Oh, thank you. Thank you.
May I please have a receipt?
You sure can.
Thank you. He was so fat. He must have been 400 pounds. He was a cop. And my signs showed to the TV camera. We're not going to turn off at the hutch.
Wall Street Journal for WCBS News Radio 880.
And WCBS 880 does feature business at 25 and 55 past every hour.
Town Commission is waiting, but first, if you are somebody who needs to file a claim with the Hartford, here are some helpful phone numbers.
For property, casualty, and workers' compensation claims, call 1-800-243-5860. For group life or disability insurance claims, call 1-888.
May I please have a receipt? Thank you. There's no need of that toll there. Governor O'Neill took down all the tolls in Connecticut. What's the matter with you, New York? After 6. And I guess I'll feed Rusty again. Then I'll go into the A&P. And I'll buy him some more things. Rye Post Office. And there's the Rye City Court. And there's Rusty Dog, who's all set. He had a big supper. Glennie bought him new food and gave him lots of water. Folks, here it is. This is the order by the Second Circuit, the United States Court of Appeals, Goldberg versus Cablevision Systems. And here is the decision in favor of Goldberg and against Cablevision. And it goes on for many pages. And in it, it says that Wexler was wrong. Wexler was wrong. He who went to the dentist and kept all the people in the courtroom waiting, people that were told to be there at 9 o'clock. He comes in an hour or so later. And he is wrong. And the Second Circuit told him to do it over. And of course, they actually vacated Wexler's decision. It was so bad. So it was sent to me by Brian Greifman, who was the amicus curiae on Glendora versus Cablevision, and we won that one. That was in 1996. This is the second time Goldberg has beat Cablevision. What was the issue? At the end of his Civil Defense Monitor program, Goldberg said, send $20 for a transcript, or was it for a tape, a videotape? And Cablevision said that Goldberg couldn't do that, and they wouldn't cablecast the program. So they violated Goldberg's public access rights under the Cable Television Policy Communications Act of 1984, codified as 47 U.S. Code 521 et sequitur. And so the Second Circuit ruled in favor of Goldberg. And here is Goldberg's press release on that matter, together with his newsletter. So this is a very big step in public access, and Goldberg and Hilgartner deserve your sincerest applause. Now, Goldberg has another suit against Cablevision. In June, Goldberg, on behalf of other Long Island public access producers, filed a separate lawsuit against Cablevision, the New York State Public Service Commission, and the town of Oyster Bay, among other things, challenging Cablevision's demands that users, public access producers, sign a contract as a condition of use of the public access channel. It also challenges the terms of that contract, alleging that it contains numerous illegal provisions. Does it ever? Officials of several Long Island municipalities also have raised objections to the recently imposed contract requirement. You can email Goldberg, Robert M. Goldberg at 516-822-2582, or ROBMGO, Rob M. Go, Gold at SPECNET. Good for you. Hooray for Goldberg and hooray for Thomas Hilgartner. This is an emergency motion, a memorandum to the court that Dolan defendants, the Group Gamma defendants, have perpetrated their worst violation yet of Glendora's public access rights under Title 47 U.S. Code Section 521 et sec, and copy of their defeat in the Second Circuit of Goldberg's public access rights. This is to the United States District Court for the District of New Mexico, and it's Glendora plaintiff versus the Jackie Sellers DCTV defendants, and the Brooklyn Domingo Martin, Anita Coward Mayer, and Nicole Gordine, the Group Beta defendants, and then the Group Gamma defendants, Charles F. Dolan, James L. Dolan, Robert S. Lemley, Mac Budil, Charles A. Forma, Maurice Cunningham, Brian O'Neill, Diane Bennett, Amy Van Horn, Christine Savarino, Brenda Cherry, Cablevision Systems Corporations, Robert Callaghy, Sadley, Stevens, Burke, and Burke. Now, those are the group Gamma defendants. And on 9/10/2001, Monday, Anno Domini, Glendora telephoned Amy Van Horn, Cablevision Hauppauge, to inquire as to a chat with Glendora on the Brookhaven system. After putting Glendora on hold, Amy told Glendora, 1, A, the signer of the Cablevision public access contract and application was called by Cablevision to verify his residency. B, said signer stated he did not want to be the signer. He reneged, in other words. C, so Cablevision did not cablecast a chat with Glendora on the Brookhaven system. D, super happened over 3 months ago, circa May 13th to July 1st, 2000. And Cablevision, Amy Van Horn and Amy Galembo, Cablevision, Amy Galembo and Peggy Anderson never told Glendora what they did. Never told. The first Glendora knew was on September 10th, 2001, Monday this week. Had Cablevision told Glendora what had happened, Glendora could have remedied the situation, got another signer, a Brookhaven resident. It is as simple as that. This is an outrageous violation of free speech of Glendora's public access rights under the Cable Communications Policy Act of 1984, codified as 47 U.S. Code Section 521 et sec. Oh, and it's also a violation of Title IX, New York Code Rules and Regulations, 595.4, and of New York State Public Service Law 229.3, limiting and prohibiting public access. That you cannot do. The people responsible for this are Amy Galembo, Peggy Anderson, Amy Van Horn, Maurice Cunningham, Mac Budill, Charles A. Former, Robert Callaghy, Sadley, Stevens, Burke and Burke, Robert S. Lemley, James L. Dolan, and Charles F. Dolan, and Cablevision Systems Corporation. Now, is the New Mexico court going to let these lawbreakers get by with this violation of public access rights under Title 47 U.S. Code Section 521 et sec? Following is the Second Circuit defeat of Cablevision against Goldberg. All right, this is the day before the autumnal equinox. It may be the autumnal equinox. It's September 20th, and the time is 5 p.m., and we're having rain. And now I think it would be a good idea to tell you some jokes. Okay. Little League is where the kid on the mound has 5 basic pitches: a fastball, a slow ball, a curved ball, a sinker, and one that you hope will get to the plate. Franklin laughed at that. At the lodge meeting, the announcement was made, "We regret to inform you that the grand, invincible potentate of the lodge couldn't make it to the meeting tonight. His wife won't let him out of the house." John wanted to give his wife a bouquet for their 25th anniversary, and he said to her, "What is your favorite flower, dear?" And the tired housewife said, "Pillsbury." And Marilyn said to her husband, George, "This is the 7th time you've been up to that buffet table. Now, aren't you ashamed of yourself?" And George says, "Oh, no, honey, I keep telling him it's for you." And Bob said to Elaine, "When are you thinking of getting married?" And Elaine said, "Constantly." In the Rye Court, City of Rye, County of Westchester, State of New York, last night, Wednesday, September 19th, was a court action that I brought against cheater landlord Godfrey S. South and his ogre son Mark South. And I prepared for the court appearance. There are 3 volumes, and I reviewed them all, and I made notes as to what to say. And I picketed in front of the courthouse. Godfrey South, cheater, landlord, lies and steals. He stole our security deposit, $1,200. I want an injunction against him that he not be allowed to charge security deposits because he abuses them. And he also commingled it, which is against the New York State General Obligations Law. You're supposed to put it in a separate account and inform us where it is and what the number is. And I talked to the policeman who acts as a bailiff for the court. And we were called to be there at 7:30. By 8 o'clock practically the judge was not present, and we were the only case. The only case. That's something. We were the only ones in the courtroom. And I went up and I stood in front of Godfrey South, his ogre son Mark, and a young lady who gave me a funeral brochure that her mother had died. And I looked at those people and I waited for at least a minute, but they were too guilt-ridden to look me in the eye. So I went on. Now the judge decided that on a small claims case for $1,200 plus the interest, plus I want $500 fine for the commingling and $1,000 punitive and compensatory damages, and I want him enjoined. So the judge's method, his name is Peter Lane, is to take us to his chambers and to try to settle it. And so South starts producing all these bills for the shampooing the carpet, and then he claimed that the dishwasher was broken. Well, I have no personal knowledge of that. The dishwasher was fine. In fact, I didn't use the dishwasher. I have a dishwasher. His name is Franklin. You turned on the dishwasher to keep it fresh and clean inside. Maybe once a week I ran it, with nothing in it usually. All right, so that's 2, and 3 was changing the locks on the door. Well, that was stupid, because if he'd paid back the security deposit and the interest, as he is legally compelled to do, he would have got the keys immediately. They were in my pocket. He could have had them. He wouldn't have had the doors locks changed. So, Peter Lane asked Godfrey South and Mark South to leave because he wanted to talk to Glendora. So he did, and he asked Glendora, is there a figure that she would settle for? And Glendora says no. $1,200 plus the interest. So he called them back in and told them, and so the date for the trial was set October 18th. You should come and see it and hear it in the Rye City Court, Rye, New York, County of Westchester, just over the Connecticut line. October the 18th, which is a Thursday, at 9 a.m. So there's lots of work to be done on that because of the cheater landlord named Godfrey South and his older son named Mark South. Rusty had a good warm night at Kathy and Ralph's. Thank you so much for protecting him And he's getting, so he likes it over there better and better, and he likes them better and better. They have 2 cats, they have a rabbit, and Trudy and Kevin, 2 children. And they're going to heat their place with a wood stove. She said she had a 1-room apartment in New Hyde Park, and it, in 1 month, 1-bedroom apartment, and it cost $600. Here, let me put the front seat back, Rusty. There you are. See, he wants to go on his ride. He wants to go on his errands. This is Friday, errands day, and it costs $600 the electric heat. So the wood stove does a beautiful job, and that's what they're going to use. Last night, we went to visit Rusty, and he has such a nice place to stay sheltered from the cold, with Kathy and Ralph and Trudy and Kevin and 2 cats and another dog and a rabbit. And Rusty is doing so well, and he's beginning to like those people, and he likes their house. On the back porch yesterday, I come to see him, of course, morning, noon, and night, an hour each time. And on the back porch, he had her near Peekskill, New York. But it's called Peekskill Hall. It's beautiful. We had a tremendous rain. It's over now. Peekskill. Folks, this is the 2nd day of fall, the autumnal equinox, and it's just as nice out as if it were August. We have had such a blessed summer. Here's a civil recall. I hate New York. I went to Bronx Neck, as you know, and here is a parking ticket, $25 at Lehman College. How can those poor kids afford to go to college and pay the civil recall of these gangsters in the city of New York, the New York City Parking Violations Bureau, the New York City Department of Finance? They are such crooks. And why aren't they down helping the people in the World Trade Center instead of passing out trivial, frivolous parking tickets? And the same goes for you, White Plains. Why aren't you down there at the World Trade Center instead of having cops passing out parking tickets? $10 parking ticket on a ticket on Quaropus in White Plains. Here is your bulletin from the Americans for Legal Reform. Their post office box 214, Huntington Station, New York, 11746. And www.americansforlegalreform.com. Over 100 links. And it says, don't vote for lawyers. Do not vote for lawyers. Americans for Legal Reform, their meeting dates are October 2nd. And the next day, October 3rd, they picket lawyers and judges at the Suffolk Supreme Court. And then they meet again on November 6th, Tuesday. And their picket date is Wednesday, November the 7th, Nassau Supreme Court. Next meeting date is December the 4th. And the next day they picket, December the 5th, at Suffolk Supreme Court. We are available for lectures and private strategy meetings. Call 631-421-6390. A large group of people will be picketing the courts at Foley Square, New York City, Friday, October 12th, from noon. For information, call Jacob at 202-213-8255. 0975. This is a matter of justice. This is the same group that we picketed with at the United States Supreme Court in Washington, D.C. on May the 6th. The most successful legal reform group in the country is back again. We'll still turn down the audio. We must be a little stronger. Many of you think that our organization runs itself. We need help. We need money. You, of course, can resolve the problem by sending to your yearly donation and getting others to do the same. There are foundations that make grants to organizations such as ours. With the thousands of people who have passed through our organization, we need one of you to solicit these foundations for funds for the Americans for Legal Reform. We need more court watchers. Many of you realize how many times we are asked. We can't be waiting on the street corner to be asked. There are 2 other reform groups on Long Island who get big fees to keep them going. One charges thousands for membership and the other has a lawyer rip off its members. If you want a list of victims, call us. We also need help writing letters to Newsday, complaining about reporters not covering the courts, calling local cable TV companies, which receives much in dollars from lawyer advertisements, writing letters complaining of the way the courts are run, and calling radio talk shows to talk about the legal system. Unfortunately, many are into me instead of we. A couple of weeks ago, the American Bar Association requested public taxpayer funding of judicial campaigns. The legal profession received $50 billion from the tobacco industry. Why doesn't the American Bar Association pay for judicial campaigns? Most of you do not grasp how many benefits the government provides the bar. For example, free use of public buildings. Did you know that the Bar Association does not pay real estate taxes? Our goal is to educate you on how bad it really is for everyone. Obviously, we have a big job. Too many of you are so into your case that you have no time to help others or to change the system so our children don't have to endure what you are going through now. Don't vote for the incumbent. Don't vote for the incumbent. Don't vote for the incumbent. Get involved with the selection as well as the election. There's another page, and I'll have to read that at another time. Now this is Texaco. Okay, this is corporate ripoff. This is corporate greed. And the Texaco merger agreement with Chevron has come in the mail, and Texaco is going to have its last annual meeting at the Houstonian in Houston, Texas, where Chevron will have its last annual meeting. Glendora will not be there, nor will Peter I. Bajur. If you remember the Texaco annual meeting last year, that was his last. that was his last. And Glendora takes full credit for that. Now, I went through this merger agreement, and I annotated it, and I said greed is written all over their faces. Goodbye, Wrigley. Wrigley died, by the way, Wrigley Chewing Gum. He was a director. Goodbye, Vanderslice. Vanderslice still owes Glendora like $300. Goodbye, cheaters. Goodbye, lawbreakers. Now we know why you would not let shareholders see the books, records, and minutes. This is my admission ticket. Would you like it? CEOs and bad companies. Do you see what happens to bad CEOs and bad companies who violate New York State Business Corporation law and then fly the flag of the state of New York outside of Texaco headquarters at 2000 Westchester Avenue, and that will be no more. Goodbye, Texaco. Goodbye, Peter I. Bijou. Glenn F. Tilton took Bijou's chair. What's his resume? And they quote over and over again, the Securities Exchange Commission, but the Securities Exchange Commission went up in horror on September the 11th, 2001, 8:45 and 10 after 9. That's where it was, folks. So this is several pages of annotations letting them know that we know that we know. Were you at the last annual meeting of Texaco, April 2000, Bijou's last? Did you witness the exchange between Bijou and Glendora? Did you see Bijou violate New York state law in front of 400 people? And the files, and he flies the flag of the Empire State out front, 2000 Westchester Avenue. So I think you get the idea. What will happen to the task reports on equal opportunity employment? The U.S. court ordered Bijou and the board to make public annually. You remember Roberts versus Texaco, the racial discrimination case? And they got out of that with a settlement of $4.75 million, but they had to write reports every year that they had improved the equal opportunity roster at Texaco, and these reports were so phony, I read them all to you. So I don't think there's any more point in reading this to you. And that went out to the new chairman, O'Reilly, David O'Reilly of Chevron. So, goodbye, Texaco. Goodbye, Peter I. Bijou. John wanted to give his wife a bouquet for her birthday, and he said to her, "What's your favorite flower, dear?" And the tired housewife said, "Pillsbury." And an archaeologist is the best husband that you can have. The older you get, the more interested he gets in you. And Bob said to Elaine, "When are you thinking of getting married?" And Elaine said, "Constantly." And Marilyn said to her husband, George, "That's the 7th time you've been up to that buffet table. Aren't you ashamed of yourself?" And he says, "Oh, no, honey. I keep telling him it's for you." And did you hear about the couple that got married so late in life that Medicare picked up 3/4 of the honeymoon? This is a chat with Glendora, and this is Sunday, the autumnal equinox. And what time is it? It's at 5 o'clock. And it is September 23rd. way, the tapes were left at the wrong desk. Instead of at Marguerite's, they were left at Maria's desk. But anyway, 4 tapes were left. It's almost right. It almost worked. Mount Vernon High School.
A Matter for Justice. I've been part of this organization for about 2 months now, but I joined them because I'm very excited about what they do. I'm not speaking on as a spokesman for the organization, but as an individual who came to a demonstration here today before the Supreme Court. I was a pro se litigant in a case that went before the Eastern District District Court. And you know, I was sort of excited to do that on behalf of a FOIA request that was denied by the government. I was disappointed about the decision that the Eastern District made, so I took my court on appeal. And what I was very disappointed to receive back from the 4th Circuit Court of Appeals was a form letter, which apparently hundreds of other individuals have received regarding their cases as well. This form letter just says that your case has been denied. It does not state any particular reason and does not address any of the issues of any of these appeals. This is sort of concerning because you pay for this service, but there's no quality control. My background as a physician taught me that it's important to have quality in the work that you do. But dealing with the legal system, I see no quality there, and no how would you say system for ensuring or reviewing to make sure that there is quality. How did I get involved in a Freedom of Information Act request? I was an Army pediatrician for almost 8 years, and from the beginning of the time that I was a pediatrician, the Army made some changes in their healthcare system, basically eliminating skilled nursing for pediatric patients. As time went on, I began to see basically accidents and mishaps occur because the people who were helping us take care of pediatric patients weren't trained to take care of pediatric patients. I brought this issue up to the quality assurance programs at the hospitals that I worked. I believe that this issue was largely ignored. Because of that, I felt it was unethical to continue to practice pediatrics for the Army, and I chose to get out. As I got out of the military, I sent a letter of complaint to my Congressman, James Moran, who forwarded it to the Army, and the Army had agreed to do an investigation. They spent about a year, apparently, investigating the issue, and when I performed a Freedom of Information Act request for the results, the Army claimed that it was privileged information that could not be released to the public using a law to protect peer review. But this was a complaint that was investigated. There was no actual medical care that was being addressed as would be performed by a physician, but only the rules and procedures of the hospital and the healthcare system itself. Because I didn't agree with the government's decision to withhold this information, I took my case to the Eastern District of Virginia. I had a hearing and received a judgment from the court stating that the information was protected. I filed an appeal using the congressional record, which stated such information was not exempt from disclosure, and received back from the Court of Appeals, the 4th District in Virginia, a form letter which didn't address any of the issues on appeal.
My name is Gisela Weishaus. Some of the people know me. They know me when I started the Swiss case for the Swiss money for the dormant accounts. I was here in Washington a couple of times. I went to Switzerland, everything. Without me, there would be no case. I worked to work up this case, and I give some people hope who were deprived of their monies that were deposited in the Swiss bank. The case became so supposedly a class action, but it's not a class action, it's a fraud action. They are defrauding us, we go in court, they make settlements behind our back without representatives. I'm fighting the system, I'm sending in affidavits, all kind of documentation where I prove that the judge's own orders is violated. They just destroy everything in the court system. In January, I wrote a letter to the Supreme Court here in Washington, and I told them they have to look into it. They cannot let the courts run the way they're doing it, fraudulently, destroying evidence, ruling with rubber stamps, when clerks are ruling, judges who recuse themselves are ruling. I mean, this is unbelievable. If we let this country go on like this, there is going to be no justice, everything is going to be destroyed. We have to get together and try to defend the Constitution. There is a Constitution, there is laws. And I had many judges, and I have friends who have the same experience. Everything is being denied, the laws are being destroyed. There is no justice in this country. I'm a Holocaust survivor. I was 14 years old in Germany. For a year I was there and working in the concentration camps. But some of my fellow survivors, they think this is even worse because this shouldn't happen in a free country, what's happening now. That they're stealing our money, they take our properties away, and everything in the name of American justice.
My name is George McDermott. I'm a lifelong resident of the state of Maryland. I've had several businesses in the state of Maryland. I am here today with Matter of Justice Coalition and the fellow citizens trying to alert the Congress and the people in the courthouses that we cannot stand by and allow the Constitution to be destroyed. Well, they do everything. The clerks of the court, especially this court here, just to give you some quick statistics, the Supreme Court gets about 10,000 cases a year. Out of the 10,000 cases, they hear approximately 80 to 100 cases at maximum. Okay. There's published documents out here now that show that the Supreme Court is actually ruled by the clerks of the court. 350 clerks in the court openly deny the citizens' rights once they, they file their claims. They bring it to the courts, hoping that the courts will enforce the equal justice under the law. I had my business stolen from me by the brother-in-law of a judge in Prince George's County. I find out 5 years later, and after 1,300 docket entries, actually 1,300 docket entries in 58 court cases, that actually the party I was up against, his sister is married to the judge. I also found out he's a disbarred Maryland attorney that all the courts are covering up for. I've had 3 jury trials. 3. I'm a lucky person. Only 2% of the cases in the United States ever get a jury trial. Okay? I'm very lucky. I've fought and I got 3 jury trials. Each time they found for me, each time the judges overturned it. Okay? You take the information to the U.S. Attorney's Office, they do nothing. Okay? You take your complaint to the members of the House and Senate in your legislative district. They do nothing about it. You take your complaints to the Judiciary Committee. They do nothing about it. Every person in that rally has lost. They're having their rights stripped from them by okay, corporate lawyers, and nobody's doing anything. It only took a handful of people to throw tea over into the Boston Harbor and start the Revolutionary War. Nobody wants to start a war, but we want our courts back. We want our courts to work within the law and according to the law. And every citizen who goes into a court, whether he goes in pro se, whether he goes in with an attorney, or whether it's a court-appointed attorney, should get due process of the law. Well, we're petitioning. We can give you a copy of a petition. We're going to petition to have all of the cases that have been illegally dismissed reopened. The problem is it's much bigger than what you think. The courts complain that they have too big a caseload. Okay? Well, that's their own fault. I went in the first time to the court and made a petition for relief with a 58-page indictment and 600 supporting exhibits showing clear fraud. The United States Bankruptcy Court stood up in front of me and the first time told me that he had no jurisdiction over fraud in his court. While it's on appeal, he goes to try to dismiss the case illegally. I pulled all the creditors. I confronted him with the evidence. And he says, I'm the judge and I'm going to dismiss the case. I said, Your Honor, could you please, for the record, tell me what you plan to do about the $250,000 that the debtor embezzled from me 90 days before he went into bankruptcy? His answer was, Mr. McDermott, I or this court could care less if the debtor embezzled $2 million from you the day before he goes into bankruptcy. Do you think that's justice? My case emanated, I used to own a business over here in Maryland. I own 3 businesses. I own a racquet club, a roller skating rink, and a hardware store. Somebody tried to buy into the business. It was a scam. He never bought into it. He stayed in. He was allegedly appointed manager. He was allegedly appointed manager. 3 months later, we find out that he embezzled money. We remove him from office. He filed for personal bankruptcy. Okay. That was the beginning of the nightmare. From that point on, all of our corporate lawyers lied to us. Everybody told us that nobody had jurisdiction, that you can't do anything about somebody in bankruptcy. It's an absolute lie. The laws are full of, the books are full of laws that compel judges and everybody to do things to stop bankruptcy fraud. Okay? I confronted the judges under 18 U.S.C. 3057, which is a criminal statute which compels all judges, lawyers, receivers, accountants, managers, anybody who has knowledge of a bankruptcy fraud going on, they are compelled to report it to the U.S. Attorney's Office and ask for federal grand jury investigation. They don't do it. Routinely, those who have money take and abuse the bankruptcy system in this country to steal from the people who don't. Corporations are using this day after day after day. And white-collar fraud has got so acceptable in the corporation. I have a videotape from C-SPAN that shows where our former U.S. attorney for white-collar fraud had a meeting at the National Press Club downtown and openly admits that white-collar fraud is costing this nation, excluding bankruptcy, is costing this nation $800 billion a year in losses. I hope personally through my website to eventually post all the cases, the case law that I have, so that anybody who's a victim can come in and look at the filings that are in courthouses. These are documented filings, and use them to prepare their own defenses. The American Bar Association openly admits that 75% of the people in the United States have have inadequate or no legal representation. Well, they took my property. Not only did they take my property, but because I wouldn't sign their documents, they took the title to my house, which I just paid off, and used as collateral for a loan for their new business, and put $600,000 worth of judgments against me. Then they formed a new corporation using my name without my knowledge and incurred $300,000 worth of tax liabilities, which they default on. So I'm standing here. I have $900,000 worth of judgments against me. No business. And Maryland has the worst record. The Maryland Court of Appeals, I've won cases in the Maryland Court of Appeals. I've argued oral arguments in the Court of Appeals. I've won 3 jury trials. The judges have tried to overturn all 3 of them. The juries have already awarded 2 years ago that the judgments should be vacated. They're still at my house, okay? If it was your house or your TV station or whatever, you'd be outraged. We need to tell the courts that the citizens count. They've got to stop protecting the justices who participate in crimes. They have to stop protecting the lawyers who are dishonest. And the thing is, it's not only I'm not against lawyers. Good lawyers have a place in this nation. But the bad ones we've got to get rid of.
My name is Daniel Young, and I'm from Raleigh, North Carolina. And I'm here this afternoon in front of the United States Supreme Court, these hallowed halls of justice, to see that justice is done, that the citizens of North Carolina and Raleigh and throughout the United States have their constitutional rights protected. Nothing can destroy a government more quickly than its failure to obey its own laws and its own constitution. Well, the only problem, one of the problems I have is that the judges do not follow their dictates. They say one thing and then they enforce another thing, and that's one of the things we're trying to correct. Well, mine is a First Amendment free speech violation. Well, I was charged with disorderly conduct for giving a police officer the finger.
What happened?
Well, I was taken to court. I was fined, and I was given a point on my driving record. The original story, I was picking up my wife from work, and I was driving my car, sitting there waiting. The police officer required me to drive around the block 4 times. And when my wife finally came out, and we drove off, I gave the officer the finger. And that's what I was charged with, disorderly conduct. Intentionally disturbing the peace. It went to court, and I've been appealing it ever since 1992. And I was entitled to a transcript and an appointment of counsel because it was a violation of my constitutional rights. The courts in North Carolina did not see fit to appoint an attorney for me, nor to provide the transcript of the trial.
My name is Dan Lumley, and I'm a Montgomery County resident living in Rockville, Maryland. And I'm protesting here today at the Supreme Court because as a resident of Montgomery County in the state of Maryland, my constitutional rights have been denied. And I was very taken aback by that because all my life I had been led to believe that the United States had the best judicial system in the world, and I'm very sorry to say that selectively the laws are enforced or ignored, and that influential attorneys can have an impression and an effect on the outcome of judicial decisions, and judges selectively enforce or ignore the law. I went to the Court of Appeals and told them that the Montgomery County Circuit Court had denied me my constitutional rights, but the Court of Appeals said we're not going to hear the case. So I came to the United States Supreme Court and I filed a petition for certiorari and told the Supreme Court that the state of Maryland was not enforcing the laws and was denying my right to due process and equal protection under the law, and the Supreme Court again did not hear it. So nobody has heard my case, and it doesn't do any good to have any laws if nobody enforces them. So I was very disappointed, and I hope people out there that have had similar experiences or know people who have had experiences can unite and maybe together we can get the legislature to change this, because right now the judges have something they call absolute absolute immunity. And nobody in this country should have the right to violate the laws against me or against you. And unless we get in touch with our representatives in the Congress and have them change the law that says that even if a judge violates the law, they should be held responsible, and that's not the case now. I don't know why they voted this immunity for all things to judges, but they did, and when they have this power, there's nothing. A judge can do anything he wants to. I guess theoretically they could probably murder somebody as long as they did it in the courtroom, and they could say it was somehow in the performance of their duty. But anything a judge does on the bench, any violation of anybody's rights is immune, and that's just not right. And I hope that something can be done about it. I know that the internet is now a means. There's a group here today called A Matter of Justice. I think it's a Matter of Justice just a matter of justice on search will find it, and there's literally thousands and thousands of people like myself that have had their rights violated. And I know you hear stories about the people who do the murders and the rapes and the horrendous things, but there are so many families that are just ruined because of the divorce machines and other civil actions taken in the courts by the crooked lawyers and the judges, and it's just a shame, and I would encourage anybody to help us do something about it.
My name is Mustafa Saeed, and I'm a victim of this court system on several occasions. I'm here to say today that the American people need to do something about the judges who sit on the bench. We're here to expose them. I'm here personally to expose them because if somebody hold up a bank down the street, they become a criminal and they're being prosecuted. These judges sit on the bench are committing treason, because when a judge sits on the bench, when he take an oath that he's going to uphold the Constitution of the United States of America, and he sits on the bench, and when the American people come before them and they change the Constitution in order to suit their friends, we feel that they commit a crime, and that crime is treason, because holding up a bank cannot be a crime as worse as treason. Judge Bryant, he's arrogant. He sits on the bench with arrogance, in complete insult to the United States Constitution, and in one day he went and said this case should be dismissed. Just like that. And then I appeal my case to the Fourth Circuit Court of Appeal. I'm doing this pro se because I didn't have no money, and all my cases, all my papers was in correct order, in procedural form. It goes to the Fourth Circuit Court of Appeal. They take the case and throw it out. This Judge Bryant, he's arrogant. He sits there. He spits on people. He doesn't care anything about the Constitution. His name is on the courthouse. His name should never be on that courthouse in Alexandria, because that man is definitely a disgrace to the Constitution. And I just want the American people to know what they're doing on the bench. And we need for them to remove themselves from the bench. If they are hired to be impartial to all American citizens, they have a duty to follow the Constitution. And if they commit treason on the bench, we want them to be removed. I think there should be a law to remove judges who does not follow the Constitution, and they should be examined every 4 or 5 months or 1 year to see if they're following the Constitution.
My name is Wesley Yost. I go to Baltimore School of Massage. I'm studying to be a massage therapist. I am not a member of this organization for the Fourth Circuit Court or any of the other circuit courts. I'm just a concerned member of what's going on in the world. And I may not have personal experiences or any stories to tell of my personal experiences with the government or anything that's corrupting this world as we know it. I just have a few things to say, just basic codes to live by that we see and hear and even watch on TV every day. The thing with this situation is very similar to the problem with the issues of the police, David Young's situation. The patch says serve and protect, not piss off and direct. As it shows the posters over there, it says George Washington would take back his name on the Constitution for this situation that is occurring right now. He would be appalled of what's going on today. He would say, forget this. I leave you with this, and you mess it up like this. What's going on here? We have a problem. In the words of George Carlin, quit setting double standards. One standard will do just fine. You do not know what you're getting yourself into. Do Do you want to start another battle of a little bighorn with the American people? For us protesting against this, basically, we in a way are stronger than you. So basically what I'm trying to say is don't start another little battle of a little bighorn. You're not going to win.
Okay guys, just a party stop for you. How many here are sports fans of any type? Sports fans any type? How many here are parents? Okay, you can use either analogy. I'm going to use a sports example, but either way, you know if you're raising kids or if you're in a battle of sports, it's not who's ahead at the beginning, it's who's ahead at the end. Since you're in it for the long haul, you're in it to the end, and we want victory at the end. You agree?
Court in Washington, D.C. and picketed against federal courts, the district courts, and in the circuit courts. 200 people came, and one of the people I talked to told about the case of her friend in Oklahoma about custody of, the friend was Victoria Gutman, and this was about the custody of Gutman's daughter. And so when I got time, I took a few telephone numbers of people there and called them up. McDermott is one of them, reporting on the rally at the Supreme Court, United States, Washington, D.C. And one of the numbers I called was the lady I talked to, who was the friend of Victoria Gutman. And Victoria Gutman called me back, and then she started telling me the horrible things that had happened in this case in Oklahoma. And Victoria Gutman sent to Glendora this letter. This was received by Glendora on September 14th, and memo endorsed by Glendora today, September 18th. And says Victoria Gutman, "Dear Glendora, thank you for responding to me and offering your help. As I have learned that my story is not unique and probably is not the most terrible one as I read about other cases. There is little consolation, quote unquote, in this, but to me it manifests the presence of a nationally spread epidemic that consumes American family courts across the USA." And Glendora says, "Indeed, you are so right." Says Victoria Gutman, "Coming here from the former Soviet Union, I never imagined that I would end up fighting for the basic civil rights in the country, which the whole world holds as an example of liberty and justice. Glendora says, you are so right. It is a terrible thing to happen to you. Gutman, I found myself in a situation that could only be described as a twilight zone. People of authority and power choose to look another way. Glendora says, indeed. While, no, my teenage daughter and I are treated as criminals for not following the court orders, the orders that were made with a malicious goal to extort money from me via endless mandates to pay for, quote, court-appointed experts, unquote, and puts my daughter within harm's way of her demonstrably abusive father. The judge is accusing me of not doing my duty as a parent. And Glendora says, this is extortion. It's civil RICO, Title 18, U.S. Code, Section 1963, and it's the judge who is not doing the duty. If I did not force my daughter to be with her father, even if I knew that he is abusive to her, says Victoria Gutman to Glendora. The story comes to its apogee when Judge Napoli decided to punish me. Judge Napoli, or maybe Napoli, issued an order giving my ex total custody of my daughter, Esther. When Esther refused to obey, she was declared a criminal and was jailed as a delinquent child. After spending 4 days and 3 nights in juvenile detention, Esther was returned to me by the Department of Human Services. The Department of Human Services recommendations meant nothing to the judge. Judge Napoli was now consumed with her quest to demonstrate her power, demanding of Esther that she will unconditionally bend to her will. Glendora says file a judicial misconduct complaint, United States Code, Section 372C1, and send a copy to Orrin Hatch, Senate Judiciary Committee, and to the House Judiciary Committee. And Victoria Gutman says, I tried to contact local media and was shocked to learn that they are sworn to secrecy. Well, I don't know what that's all about. Finally, family court is off limits, I was told. One of the correspondents said to me off the record that if I could produce a dead body of Esther, quote unquote, then they could cover this. But as long as she is alive, they cannot touch the issue. I think that's macabre, and I'm just not sure that that's true. And they are wrong, and this is America, and we have a free press, and also sue Napoli. Violations of civil rights under color of state. She works for a government, the state government of Oklahoma. And it's civil RICO, Title 42, U.S. Code, Section 1964, and it's also civil rights, Section 1983 and 1985, conspiracy. Victoria Gutman says, I turned to teachers at the local high school hoping that they would help support Esther, knowing her as being a straight-A student. I have been told by the school's authorities they cannot interfere, and if they were to do so, it would jeopardize their careers. There was only one teacher who knew Esther for several years in her middle school who had courage to write a letter to the local courts on this subject. The rest chose to pretend the problem does not concern them. This is bad, bad, bad. Says Victoria Gutman, the local political representatives told me that since it is a family court matter, they could not get involved. You understand that this is all going on in Norman, Oklahoma.
A few of my friends and Esther's classmates wrote letters of protest, see the attached, to the local court, and that resulted in a recusal of Judge Napoli. I was hoping that our worst days are over, but it was not so. Well, first of all, congratulations for getting this judge to recuse. That's good. Now, here's what you have to do. You have to sue her, you have to picket her, you have to expose her on TV, and you have to file a judicial misconduct complaint against her. Okay. So I've read you page 1, and when I get time and strength, I'll continue reading it to you. And the reason I'm reading it to you, not only to show this to you in New York, to show you that things are bad all over the country, but I want this program to go on TV in Oklahoma, where the injury is. This is Glendora, a chat with Glendora. A chat with Glendora is seen on 22 cable systems all over the United States. And a lot of the time on a chat with Glendora is spent on standing up for people's rights in court. So I will continue this letter later in this situation. And we will help Victoria Gutman from others. Now, folks, this is Victoria Gutman's second page letter to Glendora, with Glendora's marginalia and interlinears. Writes Gutman, for political reasons, no other judges from Cleveland County wanted to take our case. And so we were, quote unquote, farmed out to another county judge, Judge Siggs, S-S-A-M-E-A-G-G-S. Siggs, Sags. And I need the first name and the initial, Victoria. Judge Skaggs decided to support Judge Napoli, or Napoli, and ordered the same. Custody goes to my ex, and I am to pay my ex child support. And if Esther, the daughter, refuses to go and live with her father, as an added punishment to me, I am to pay my ex's attorney's fees. Glendora says, outrageous. And I think there's collusion between Skaggs and Napoli. And they must, and Victoria, you must file a judicial misconduct complaint. Says Victoria Gutman, during all that time, Esther, daughter, would not reveal to me or anybody else the reason for her unwillingness to be with her father. She would just say that he is, quote, mean and abusive to her, unquote, but would not go into any details. She would say to me that, quote, it is between her and her dad, unquote. Finally, she said that her father told her that, quote, he can do with her whatever he wants, unquote. That made me wonder what was really going on her visitation days, quote unquote. I decided to take Esther for evaluation. See the attached report. Says Victoria Gutman. Esther's abuse by her father was reported to the district attorney, police, and the Department of Human Services, but no charges were filed against my ex. I have been told by the police detective that even though normally they would have prosecuted a case like this, but they are not going to do so because it will make judges look bad, and after all, my daughter was not really raped. There was no intercourse, just improper touching, and of course there were no witnesses. he explained as to assure me that it is not a big deal. That's bad. And we need names. We need names of all of the people who are described herein. My daughter, says Victoria Gutman, is staying with me now, yet we are both in contempt of court. Every day she is with me. We live in fear for what will come next. An attorney of my ex said that her goal is to bleed me financially so I would have no means to continue to protect my daughter. So far, my battle for justice exceeds $70,000. That's the old civil RICO. Title 18 U.S. Code 1964. D. Civil RICO. Extortion. Glendora says, I need the name and affidavit under penalty of perjury. This is civil RICO extortion. Says Victoria Gutman, Glendora, I'm asking you to include this topic on your talk show as a forum for discussion of this matter. Says Victoria Gutman. I want our story to be known to as many people as possible. I hope that if enough people will come forward with their stories, we can make a difference and stop Family Court of America becoming the best kept secret of being chambers of horrors and tortures of our children. I want justice and decency restored in our case as well as other families that I know do exist. Let our children go. Respectfully, Victoria Gutman, 1718 Village Drive, Norman, Oklahoma, 73071, 405-321-7230. Glendora needs the name of the court and the address of the court. It is widely known, says Glendora, but not enough. So is matrimonial court. That's another chamber of horrors. Now here is a complaint to Justice Lucas from John L. Cochran, Ph.D., about this situation with the daughter Esther. The father is a mathematics professor at the University of Oklahoma. So, we'll work on this again some other day. Bad situation. And I'm in New York. I've been telling you about New York courts for years. You can see that the epidemic, the disease, is all over America. This one is in Oklahoma. Hearing said, now folks, I would like to read you what Sage said. Dear Justice Lucas, near the end of Melville's Billy Budd, the young sailor stands condemned to be hung on the yardarm in the morning for offenses to which he was innocent. Although the officers realized he was blameless, maritime justice called for capital punishment. This circumstance evoked the captain to say, quote, "This has nothing to do with justice, Billy Budd. This has to do with the law." In recent days in Cleveland County, Oklahoma, there has been an unfortunate event leading to the arrest and detention of a popular high school girl. I am sure you are aware of the circumstances whereby 15-year-old Esther Gutman was held in detention for 3 days. I also suspect you are aware of the public outcry that this injustice has produced. I say injustice, quote unquote, as I have studied the circumstances surrounding this event and can find no logical, moral, or judicial precondition that would have armed police invade the mother and young girl's home and seize her for the crime of fearing to go to her father's home. Judge Napoli has apparently been somehow induced to break this child in the most heinous exhibition of judicial performance in recent memory. Yet no one has asked the most simple of questions in this effrontery, namely, why is the child afraid to go to her father's home? Judge Napoli, or Napoli, whichever, has been so consumed in her desire to make the child submit that she has overlooked, or has been persuaded to overlook, this most essential point. Perhaps the I's have been dotted and the T's crossed as far as the legality of the circumstance stands, but just as with the narrow nature of the maritime laws under which Billy Budd was executed, Judge Napoli has shirked her most basic responsibility in dealing out her punishment. She has lost sight of, or chosen not to seek out, justice. For political reasons, no other judge from Cleveland County wanted to take our case, and so we were farmed out to another county judge. Common sense would have told Judge Napoli's emotions tethered long enough to survey the problem that she herself has caused. Why would this little straight-A student, who has no malice or hint of insurrection in her body, be so resistant to visit her bizarre-acting father's home? This man has a history of arranging detention and psychological evaluation of those who oppose him, and he has now attempted the same thing on his own daughter while in detention. Of course, he and Judge Napoli appear to be in league on this account, as she has publicly declared the shy little girl a criminal, quote unquote, in her court. Then for 3 days she left the child incarcerated, refusing to go along with the Department of Human Service strong recommendation that the child be returned to her mother's home. Judge Napoli's behavior is much more aligned to that of a Spanish Inquisition prosecutor than that of a local judge dealing with children. Something is terribly inappropriate in this pitiful display of unrelenting power. We have so many delinquent kids in our community who consistently avoid the wrath of judicial punishment. We have many circumstances where the Department of Human Services lets kids fall through the cracks and remain vulnerable to the dangers of society. Then we have Judge Napoli having officers invade, arrest, and incarcerate an innocent child for the crime of being frightened, says Glendora, Gestapo. Judge Lucas, despite the public outcry, we have been successful in keeping the news media away from this Cleveland County court charade. But it amazes so many how this local judge can act so carelessly and so maliciously against the best interests of children without a yarndarm in her court. Sincerely, John L. Cochran, Ph.D. This case, again, for any of you who tuned in late, is in the state of Oklahoma, the county of Cleveland, and the town of Norman, or the city of Norman. And it's the case of a 15-year-old who has wrongfully been taken from her mother and given to her father. wrongfully alleged, and I am reading you why it is thought to be wrongful. This is Glendora, a chat with Glendora, on 22 cable systems, and very often a chat with Glendora stands up for people's rights in court. As this Judge Napoli, or Napoli, however she pronounces it, I'm not in Oklahoma to tell you, is pictured here. This is a very, very common portrait of judges. I have seen it happen for years in the state of New York, on all levels. The municipal courts, county courts, state courts, and federal courts. So this is another Dorian Gray portrait of a judge, the kind of a judge with which, or with whom, I am very familiar. A chat with Glendora knows how bad judges are. A chat with Glendora knows how bad judges are and how bad lawyers are. And it has to have comic relief, so I'm going to tell you a few jokes. The lawyer said to the client, "Before I take your case, I'm going to have to charge you a retainer fee of $600. That entitles you to 2 questions." And the client said, $600, 2 questions? Isn't that expensive? "Yes, what's your second question?" There was a collision between 2 cars.